Hey, Larry.
Hello there.
How's it going tonight?
It's going fantastic. Is this the party to whom I'm speaking?
This is definitely the party to whom you were speaking.
So only our old timers will know the Lily Tomlin skit.
That is right. Um, yeah, you threw me for a curveball with recording early. So here we are. We're recording an hour early. And I think I have all the buttons and all the stuff pushed the right way. We're recording. I got right levels and all that. So
Fantastic.
yeah. Uh, so
Let's
we're,
let, let's fire this mother up.
Yeah, so we're going to try and make a big push. I need everybody that listens to this, do me a favor and share it with somebody. We're trying to get our numbers to grow. I'm trying to keep Larry on board, and with the numbers we have, he's skeptical. We need more. But if you could go tell your buddies at treatment class or somebody down the road, your girlfriend, your mom, whatever, get them to subscribe, get them to listen to it. Maybe they don't like it. Maybe they do. And otherwise, you could leave a review at iTunes or Stitcher or something like that, and that would be greatly appreciated.
Well, thank you. Didn't we have a whole plethora of comments this week?
You know, last week we had a whole bunch, and I don't know where they went. They were for the previous episode, but not this week,
Hmm.
which is kind of weird. I don't know where everybody went, but so
Maybe we've explained it so well they don't need to ask any questions.
that's very possible. This first one comes from KALB, bill to remove nonviolent and non-sex offenders from habitual offender law voted down. Now, you are like the king of nuance on these things where I don't see how this relates to anything that we're talking about, but you see this as an angle for us to talk about it as a teaching example. So a couple weeks back, we talked about getting to know your legislator. And so possibly one of the next steps would be moving things into discussing about committees. And in this particular case, there was a bill going through in Louisiana that would, I guess, make punishment less harsh if you are a habitual offender. But it failed. And specifically, it failed because the way the vote came down, it was 9-7, with the Republicans voting 100% for it, the Democrats voting with -1 100% against it. However, they're split, so the Democrats can't do anything. They just don't have the numbers to make something like this pass.
Well, let's just be careful how we describe it because the Republicans voted against it,
Okay, my bad. Okay.
100% against it. So But I see quite the correlation because the title of the story is "Bill to Remove Nonviolent Non-Sex Offenses from Habitual Offender Law Voted Down." So the relevance is that this was a tiny proposal to loosen the habitual, to make the habitual enhancements less tough, and it was sponsored by Representative. It was a House bill sponsored by Representative Chad Brown from Plaquemine.
No, Plaquemine.
So I thought that you get a kick out of that. We
Yes.
just went through that in the pre-show interview, but from Plaquemine, Louisiana. Sorry for you Louisianans. So he sponsored it, and as legislation moves, it moves through a committee process, and it says a House committee. I'm assuming it was something to do with judicial, but they don't name the committee. But let's start from the beginning. Who the party that controls the majority in a legislative body in the House, that the ratio of committees, you only have so many committee chairs. So many seats in the committee. So you have standing committees and you have chairs. The party that has the majority gets to name all of the chairs of the committees. And the party who has the majority gets the most votes on each committee. So the Republicans being the majority party in both the Louisiana Senate and the Louisiana House, they have the majority on all the committees. So as this bill sponsored by a Democrat, it had an uphill battle because being that there were not a majority party, there was no way to get it out of committee without Republican votes. Well, they got every single Democratic vote for the proposal, but they didn't get a single Republican vote. Now, one Democrat stayed on the sidelines, but that still would not have been enough because the Democrats were in a minority status in Louisiana. as there are in most state assemblies around the country. So it was not able to get a majority, which would advance it to either the next committee if they do multiple committee assignments, or if they only do one committee assignment in Louisiana, it would go to the House floor for a vote. And so the teachable moment and the benefit for people to understand is whoever you hand the majority control to of your state capital or to your United States capital, whichever the case may be, they control the committees, they control the calendar, they control the chairmanships, and you have to get things out of committee before they go to the floor for a vote. This bill didn't make it out of the committee because not a single Republican was willing to vote for it. So therefore, it died.
And you said something earlier about the ratio in the committee is similar to the ratio in the larger body?
That is correct. So, for example, let's take a 15-member committee. Say everybody wants to be on judiciary that has any experience in law. So you have usually more people wanting judiciary. So that's usually one of the larger committees. And you have other committees that are large, like finance and budget and those type committees that people want to serve on. So a large committee, let's say it has 15 members. If the party in the majority has 2/3 of the majority, if their membership, if it's a 100-member body and they have 66 members of the 100, then they're going to have 2/3 of the membership on that committee, generally speaking. So that on that 15-member committee, 10 of them would represent the majority party and 5 of them would represent the minority party. The minority party is not going to be able to pass anything without getting people from the other side to join. And poor Chad Brown didn't have any Republican support.
Well, so and then at the federal level, it's 51-49 if I'm not mistaken. So in a 15-member body, would that be 8-7?
It would likely be the split in the U.S. Senate, where we're so close to being evenly divided at 51-49. You have the vice president in the position of casting the high-breaking vote for the main body if in the full Senate. But the committees are all chaired by Republicans, and the ratios are almost even, but the Republicans have at least one more member on every committee, so that they have the majority control of the committees.
And I'm just going to ask this stupid question. The chair is just the HMFIC. He's the person in charge of, is he in charge of scheduling when they'll have their little powwows about a bill?
Absolutely. The chairperson is really the head, whatever you said, in charge. They determine the order that legislation is going to be considered. So for example, in the state assembly, as bills start getting introduced, they're being referred to committees, and the process begins to stack up. You have a traffic jam because more and more things are being referred, and depending on the type of legislation, certain committees get more and more referrals. You could probably, on most state websites, you could find out the committee referrals, how many each committee has had how many bills. So the chair has to decide when they're going to hear, whether or not they're going to hear a bill that has absolutely no support among the committee members is not likely to even get a hearing. So the chair looks at that, and if the person who sponsored it may not be a member of the committee. That member may just come to present the bill if it gets a hearing, and that member is trying to get his or her bill heard. And if there's absolutely no support, they did that just to placate a constituent of some. I'll sponsor this for you. I'll introduce it. Then the bill's not likely to get heard because there's typically dozens, if not sometimes over 100 assignments waiting for hearings, and you only have so many hours in a day, particularly in a part-time legislature that's meeting 30, 60, 90 days a year.
Right. I was I had pulled up a page, and the Louisiana legislative salary, the legislator's salary is $16,800 per year, $16,800 per year. So they're obviously not doing this full time. No,
they're not, and of course that's $16,000 more than what we get paid in our state here.
You guys
have it unpaid.
Really?
Yeah, we're the only one that has no salary. New Hampshire gives them like $100 a year, but ours they get a per diem of like $155 a day while they're in session. That's to defray the cost of their housing and food while they're in session.
Okay. Are you just supposed to do it for being like an altruistic, like, hey, you're supposed to represent your people and do the right thing so they don't pay you?
I don't know why there's such a animosity towards paying in New Mexico, but every time it's in our Constitution that they get a per diem and no salary, so the Constitution would have to be changed. there's been attempts to change the Constitution. The people, they vote that down every time it's been presented. So in order to get the per diem up to the level it is now, they had to use trickery. Our original wording of the Constitution said they would receive a $75 per day per diem, and as time passed, $75 diminished in value.
Right.
So they tried to propose an increase of the per diem, and that was voted down. So what they did is they created a way to punish the lawmakers by saying that they shall receive a per diem no greater than the IRS, some kind of federal IRS rate set for travel. And so now it's tied to what the IRS rate is, and they used trickery to get it up to the level it is now, and it adjusts a little bit for inflation. But the people here, they don't want to pay. They're crooked enough as it is. I mean, they're on the take, every damn one of them, and we don't want to pay these scoundrels anything. So,
oh boy, we're going to get emails about that for sure.
So, well, the Louisiana, I just looked up here, says they shall convene the last Monday in March and meet for no more than 60 legislative days during a period of 85 calendar days. So they have 85 days to do they can meet up to 60 days. In odd number years, the legislature is to convene the last Monday in April and meet no more than 45 legislative days during 65 days. So they have a 45-day session, and they have a 65-day session. 60 days and a 45-day session. Now, if you've got easily, I would suspect they have in the high hundreds, if not over 1,000 bills at each session to look at. You can see that time runs pretty short, and getting things heard is very, very difficult.
Which leads us back to having things segmented out into little committees. So you're not dealing with 100 or whatever the number is for those 39, and then how many are in the House? I forgot. You said
105 members in the House of Louisiana and 39 in the Senate. So
you got to break people apart into small groups so you can get anything done.
That's the committee process. But see, the people don't understand that if they don't hang out in their capital.
Right.
Well, if you're in committee, you can't be on the floor voting and debating. So you have to divide. A legislator's day is divided between whatever committee is that they sit on. They have to hear bills in committee, but then they go to floor session and they hear things that have made it out of committee is on the floor, and they do debate on the floor. Then they have constituents who want to meet with them. They have lobbyists who want to meet with them.
Right.
And so from early in the morning to late in the evening, they're either in some sort of legislative function or meeting with people and lobbyists and constituents, and it's a constant tug of war. It's a horrendous pace that they keep. I really admire that you've got some of these people that are quite up in years, and they work these very long days, and they get longer as the session progresses, because as you get toward the end of the 60-day session, you're trying to cram more and more things in. So they're adjourning at 10 o'clock at night, 11 o'clock at night, and coming back at 7 in the morning and going to committee. So it's a tough job.
Well, suppose so. Let's just say Larry Do-Gooder is in Louisiana, and he has some sort of bill that is going to be he would like to have sponsored by a Democratic legislator. And so you bring it to him, and it's going to be something controversial. Something that we spoke about earlier was we were talking about a prison related issue. What were we talking about?
We're talking about the overpriced canteen
that's right. Okay.
Services.
So you want to have the price of soups reduced from being 50 cents a pop, because you can get them for 13, 15 cents at Walmart. That's totally gouging the people. So you want to present this bill. So you find you can't go talk to just your local guy, because that person, and when I say guy, I mean gal too, your legislator could be on the committee, but maybe not, right?
Correct.
Okay.
Anybody can introduce, any member of the legislative body can introduce a bill.
All right. But you immediately push back and go, well, when you speak to him, he's going to ask you, he or she's going to ask you back, do you have other supporters?
That is correct. When carrying, as it's called, carrying a bill is a lot of work. So the more bills you want to carry, the more work you've got to do, because as the sponsor, you're going to try to lobby the committee chair to find time to hear your bill, and you're going to try to build support for the legislation. What if you're starting from scratch? People just think the magic formula, if I can just go find a sponsor, that's not enough. that's the first step. It's an important step to know that you've got sponsorship, but sponsorship alone will get you absolutely nowhere for something that there's no support for. So the sponsor, when you go to him or her seeking, they're going to want to know, they're going to look at it, they're politicians, they're going to know how controversial this is going to be. So for example, if we're going to try to pass a law that says the Georgia Department of Corrections shall charge no more than their actual cost for commissary items plus a 10% handling charge.
Right.
That would be something that would automatically be controversial. Any lawmaker would figure that out. They would figure that out because the profits on commissary are a part of the prison's budget, and each corrections department handle it differently. They may put it in the general prison budget, or they may put it in a specific inmate welfare fund. But that's going to be controversial. So the would-be sponsors want to know, who have you talked to? What does the corrections department say about this? How will this impact their budget?
And but if your legislator is or isn't part of the committee, how does that influence you presenting that bill to them?
Well, you don't know what committee it's going to be assigned to. So that's a process that happens later.
Okay.
But you can guess, if you're knowledgeable in the legislative process, what type of committees. There again, that's why you have lobbyists, because the average Joe on the street or the average Jane is not going to know that if you presented a bill like that, let's say that commissary makes up 2.5% of Georgia Department of Corrections revenue for supporting their budget. Well, you've not only got a fiscal impact on their budget, you've got a major policy change in the mentality that the inmates should help contribute to the cost of their upkeep. And so you've got a number of entities that are going to be involved in this. So you might get this through an assignment to a judiciary and maybe to a budget or finance type committee. So you don't know where the bill's going to go. What you do know is that you're going to try to find someone who's receptive to the idea of what you want to do, and you hope that they're in the majority status, because that's going to make it a whole lot better for you. If you take this to a liberal Democrat in a state that's under overwhelming Republican control, you're not likely to get very far with it because you haven't got Republican buy-in. The majority party controls whether this gets to the executive.
And that's why I was bringing up this example against this situation in Louisiana of saying that you would have brought it, say that you brought it to Representative Chad Brown, and he's like, sweet, this is awesome. Larry, we're going to run this and we're going to try and get it through my committee. And
well, it wasn't his committee. He was just presenting the bill. He's not the chair of the committee.
Oh, this is so complicated. All right. So, well, I know he's not the chair of the committee. I realize that part. I'm assuming
we don't even know he's on the committee. Is the sponsor of the bill. You're going to be called on to present your bill to whatever committee it's been assigned to.
And this is just anybody presenting a bill to whatever committee.
It's not anybody. It's the sponsor of the bill.
Yeah.
Has the duty to present the bill to the committees that have been assigned to and convince the committees that this is good public policy.
All right.
So that they'll endorse it. So Chad Brown started out where he was in a 60-40 relationship where 60% of that body is Republican and he's a Democrat. So he knew starting out that he needed bipartisan support.
And
because he knew that he could never get to the finish line with just his own with his own party membership.
As you say, his own kind.
Well, I can't say that on the podcast.
You totally can say it. All right. So, and then ultimately it failed because he couldn't get any of his kind to come on board with it. And 2 people sat out of the vote, 1 from each camp, and that made the vote 9-7.
So yes, there was a Republican that did not vote. I think I remember the story, and a Democrat that didn't vote.
Correct.
And there could be any reasons for why they're not voting. They could have not voted because they were sick. They could have not voted because they deliberately took a walk when it came time to vote. And there's no way to know why they weren't listed. They could have been presenting a bill at another committee that they were sponsoring that happened to be having a hearing at the exact same moment. Because if you look at the 24-hour clock, and if you have 9 committees in a legislature and they all go into session, there's going to be things being presented in multiple committees simultaneously. And if you happen to be sponsoring one of those, you get up out of the committee that you sit on and you go to the committee that's hearing your bill and you present it. You have your chairman excuse you from your committee, and you try to do it at the best time. You try to work out the time where it does the least amount of damage, because there used to be a lot of collegiality in the process, and lawmakers try to work to minimize the disruption so that that they're not being taken away from their committee when a crucial vote's coming up. But sometimes a crucial vote comes up while you're presenting a bill someplace else, and you don't get to vote.
Yeah, and you use the term collegiality, and so back before we had this hyper-partisanship mentality, it is possible that these two that sat out, one from each side, one couldn't make it, so the other ones took a walk, as you said, just to make sure that it was a fair. So one sat out, the other one sat out also.
That is correct. There was a lot of statesmanship that tried to keep the process fair through the ages. A good example that our older listeners will remember, when a senator died in office, or a representative, but particular senators, oftentimes the widow got appointed to the Senate. They had no political experience whatsoever. But it was not to grab a seat that you didn't get elected to. So a governor appoints people in most states to replace a senator who can't fulfill their term, at least temporarily, till an election can be held, so that state has representation. Well, they didn't used to grab Senate seats that they had not won. They would give it to the widow, and they would take let the next election cycle roll around for a special election or the next scheduled election, depending on the calendar and the requirements of that state, and then they would fill that. Collegiality, no one required them to appoint the widow. They did that. Well, the same thing when you have an ill senator. If you're in like the U.S. Senate is almost 50-50 divided.
Right.
If Senator Cochran is too old and too frail, and he's at Walter Reed Hospital and he can't get to the Senate, in the old days, there would be a person on the Democratic side that would sit out, so the ratio would remain the same when the floor vote came up, so that there was no advantage. A lot of that has died away now. You don't. It still happens, but not to the extent that it once did.
Yeah, obviously, John McCain is brain cancer, and he has missed a lot. They were flying him in for those critical votes for the healthcare issues. So, but they weren't. They were totally using that to gain that extra advantage and putting him on life support.
And I guarantee you that no Democrat would have been willing to sit out that important vote to try to make sure it stayed fair.
Yeah.
Not in these days.
No, I know. The other part of this that seemed interesting to me is we were talking before the show a little bit about like the specifically for this bill. So you are a person that gets to stand in front of the judge multiple times. And just by doing that, you end up in a strategic disadvantage. And this bill would have given you a little bit more of an advantage. But you were bringing up that the defendant is possibly going to be like mad at his attorney saying, why can't you get me a better deal? Well, you're the one that brought yourself in front of the judge again.
So, I'm going to try to, having not read the legislation, I'm going to try to tell you what I think it said based on the title and the article. Most states have habitual sentencing enhancements that are available. So if you have a second or a third, or it depends. Oftentimes it'll just be if you've had a previous felony conviction anywhere. Well, some states are more narrow. It has to be a previous violent felony, and that they define violent felonies to be crimes of shooting from a motor vehicle or blah blah blah, domestic violence, whatever they do, however they do. So this apparently Louisiana includes all felonies for habitual enhancement. So if you have that magic second or third felony, then not only the basic sentence. So say you commit a felony that carries, it's a low-level felony in Louisiana. I'm thinking since it's a southern state, their sentences, their ranges of sentencing are going to be harsher than ours are here. On a low-level felony, fourth degree, in New Mexico, the maximum sentence you can get is 18 months. But I suspect the lowest level felony in Louisiana probably carries a maximum greater than 18 months. But say it's a low level felony, and say that they can only get 3 years for the felony, but it's their second or their third felony, then they're subject to a habitual enhancement, and that may be an automatic 5 years. What this was going to do was to remove nonviolent felonies from the list of things that would be enhanceable, and it was going to remove, it says, nonviolent, non-sex offenses from habitual law voted down. So they were going to, the sex offenders weren't going to be escaping any habitual enhancements would be available. But when you're negotiating a deal and say that you have a low-level felony in Louisiana, and the prosecutor comes to you and says, sir, I've got a great deal for you. I can give you up to 5 years in prison on this low-level felony. And I also can give you a 10-year enhancement for you being habitual. I got a great deal for you. I'll give you 3 years maximum, and I won't file the habitual proceedings. I won't use my habitual tool that I have in my arsenal. Well, that, even though they might have a weak case, the habitual enhancement is so terrifying because it's a low-level felony that the tool that they have to enhance you with is so persuasive, because if you guess wrong and that jury or judge convicts you, you're going to get the 5-year maximum on the low level felony plus the 10 years, and the judge is going to stack them consecutively. So that puts you at a serious disadvantage when you're negotiating. But the attorney didn't set that up for you. The attorney didn't make that rule. The people you voted for made those rules. The attorney is just the unfortunate messenger that has to tell you this is what you're facing if you get convicted.
And unfortunately, same thing with the DA. The DA didn't make the rules. He is just using the tools that have been given to him by the legislatures.
Well, but there's a little unfairness in that because the DA sought those rules. The DAs are heavily represented in the legislative process, and they constantly lobby for additional tools, as they call them, to put away bad guys. So the DA personally, it's on your case, may have not had anything to do with it, but the prosecution apparatus had plenty to do with those tools being available. They lobby for them, they speak in favor of them, and they tell the public how much safer they are because of these tools. So indirectly, the prosecution has a lot to do with these tools.
Fair enough. And in the final paragraph, Pete Adams, the executive director of the Louisiana District Attorneys Association, said the existing laws give district attorneys the tools they need to keep their communities safe from career offenders. And so back to nonviolent offenses, I'm thinking of someone that just writes a lot of bad checks, and that can eventually become a felony. And fine, you're a repeat offender, and yeah, you should be punished. But I'm not really sure how we're keeping communities safe from crimes of that nature.
Well, that's the whole debate as to, do we use our prisons to warehouse people that we're mad at, or do we use our prisons to warehouse people that pose a significant threat to us? That's the age-old debate about what do we use a prison for. We tend to incarcerate a lot of people in this country that we're angry at, that we find their behavior irritating. But there would be other options that would inflict that need for punishment and vengeance that we feel so strongly, but we're not willing to try those options because the only thing we know is hard incarceration.
And we don't want to have the next person down the line doesn't want to be elected and be considered, well, you're soft on crime.
So,
man, I hate it.
But we've got a significant number of people who are on the conservative side of the political aisle, and those of you here in Louisiana, you need to work really hard to convince the Republican side of the aisle to be more receptive to this type of reform. Because all the Democrats, every single member of the Democratic caucus voted for it. And 100% of Democrats supported it, and 100% of Republicans opposed it. So I can't change the reality of what the numbers are.
So moving onto a big decision that occurred at the Supreme Court level this week. And again, you are playing three-dimensional chess and pulling something out of this that I don't think mere mortals would normally pick up upon. And it is a case involving a legal immigrant from the Philippines named James Dimaya, which we are debating over how to pronounce it, Dimaya. And he was convicted of 2 first-degree burglaries in California. And in doing some research on that, they considered them nonviolent burglaries. And I know in my state, if you break into somebody's house, it's home invasion, and I think it's a 10-year minimum right off the bat, and it's going to be considered a violent felony. Anyway, so this happened through the Obama administration, and after the second offense, they were going to deport him. And it got appealed and ultimately makes its way to the Supreme Court, where they overturned the ruling for him to be deported. And I'm going to totally let you pick it up from there, because I'm going to get muddy and murky with the details.
Wow, well, thanks a lot. So now I don't know what a first-degree burglary is. I did not do that research, but it probably has to do with the value of what was burgled, but I don't know what it is. But after his second offense, he was a lawful resident of the United States, was here with his green card, as they used to call them, and had been vetted through our processes. But one of the things that happens to people who are lawfully here is that if they break the rules, they're subject to deportation because it's not a license. It's not a license to do whatever you want. So after California finished prosecuting him, the immigration it's what is it called these days?
ICE.
Yeah, it used to be called. It had a different name, but anyway, the Immigrations and Customs Enforcement, or whatever it is these days, they decided it used to be INS, the Immigration Naturalization Service. That's what I was looking for. But the immigration judge held that his first degree burglary is a crime of violence, as determined by the Immigration and Nationality Act. So that's what was at issue in the Supreme Court, was the Immigration and Nationality Act. And the definition of a crime of violence, the Supreme Court felt was what not only felt, they decided on a 5-4 vote that the definition of a crime of violence was not sufficiently clear, therefore it was void, and it was vague, and it was unconstitutionally vague, and therefore they voided that which means that he won't be deported yet, because their lack of clarity in what constitutes a crime of violence, and you can't just throw everything in the kitchen sink in there and say that these are crimes of violence. The relationship that has to us is that there are many crimes that are listed that are not violent, not just sexual offenses. An awful lot of sexual offenses. Solicitation of a minor is not violent, but a lot of our states have that as a violent offense. If you solicit someone under 15, 14 years of age, that you've committed a crime of violence, and they label you a sexually violent offender. So the 94-page opinion, which had more dissent from the conservative wing of the court that it had, that took the majority to explain their position. So I haven't read all 94 pages of it, but it's clear to me that we have additional guidance in terms of how violence has to be defined. So I think that this is going to give us the ammunition we need to go back and attack a lot of these registration laws where they've just arbitrarily clumped people together and say that you're a violent offender because you've been convicted of whatever the offense is because of the age of the person. I think that since the void-for-vagueness doctrine is what's at stake here, and let's go into that a little bit. For something to be void for vagueness, it has to fail on from a couple of perspectives. You've got the law enforcement perspective and the citizen perspective. So we have to construct statutes with sufficient clarity to give a person of ordinary intelligence reasonable notice of how they can comport their conduct to the requirements of law. So what's expected of them and what they cannot do. And reasonable ordinary intelligence, it's a little bit ambiguous, but I'm guessing that ordinary intelligence means a person who has a high school or thereabouts education, because that would constitute 80-90% of the U.S. population.
Someone that can read the newspaper, I think, is like the bench for that.
So we've got to have sufficient clarity, and people say, I've got a great friend who says we should just have a speed limit that says too fast for conditions. That is completely vague. You don't know what you need to do to comport your conduct to the requirements of law. If you had a law like that, the speed limit is whatever safe for conditions. Okay, well, everybody is different in terms of their operating skills, what type of vehicles they're driving, how well they handle, how well they corner. Their age affects their reaction times. That's the most ridiculous thing I have ever heard in all my life. But that would be an example of something that would not give you as a driver sufficient notice of clarity so you would know how to conform your behavior to the requirements of law. Then the other half of the equation is law enforcement has to be narrowed in terms of they can't have so much leeway that it leads to arbitrary and capricious enforcement. So with too fast for conditions, a law enforcement officer's opinion would be, well, as far as I was concerned, it was a little hazy. The fog was a little bit up, and the wind was blowing, and your car was kind of a higher profile, and it wouldn't corner well, and you're getting up in years, and I think it was too fast for conditions. That would give the law enforcement officer the opportunity for arbitrary and capricious enforcement. So that's what you're looking at for void for vagueness. So the Supreme Court said if you're going to take away something as precious as the privilege of being in the United States lawfully and put them on a boat or a plane or however they were going to deport him back to the Philippines, I guess it'd be either a boat or a plane. I don't think you could send them across the border like we do from Mexico.
It would be hard to drive.
If you're going to do that, you're going to have to tell these people while they're permanent residents what specifically is a crime of violence in a way that they can understand it. It can't be left up to an immigration judge to decide on a case-by-case basis what is a crime of violence. So you have to define violence, boys and girls. You have to define it so that they know that if they engage in criminality of a violent nature, that they will subject themselves to being kicked out of the country. That's all they said, and that was the correct decision. And I'm going to do something I rarely do. I'm going to commend our newest justice of the Supreme Court, Judge Neil Gorsuch. He actually sided with the liberals. He actually got this right. He got this decision right. I think it's the first decision since he's been impaneled on the Supreme Court that I agree with him, but he got one right. So hooray. Like the broken clock, he's right once, and we need to acknowledge that. The conservatives are not so happy with him, but I think he got it right, and he deserves recognition.
He is he's a unique individual in that he leans conservative, but he has a completely different view of how the whole thing is running and what is good or bad. The case where he decided with the truck driver who was out in the cold and his truck broke down, and I can't remember the details of it, but it was right after he was put in place that this issue came down, and he sided with the trucking company, if I'm not mistaken, against the individual safety, that he had other options. He wasn't completely, it seemed he sided with a bit of a cold heart to me in the way that
I think that was a case actually that was decided at the circuit level that he got grilled on when he was in the confirmation process. I don't think that's a case that's been before the Supreme Court, but yes, I remember the facts of that, and he came down on the side of the trucking company. But if he's of the Scalia mold, which that's who he says his mentor is, that is exactly consistent with what they would do. Laws that you don't like should not be invalidated simply because you don't like them. And so a person of that mindset, a Scalia would say, I'm sorry that the penalty is 10 years for this. I didn't make the rules. I didn't sit in the legislative branch. This is a decision for the people. I'm just looking at black letter law, and it says if you do this offense, it carries up to 10 years. So therefore, the right of the people is at stake here. This is black letter. So the punishment stands. Then you have people who want to look at how fair it is, and that liberal do-good mumbo jumbo of people trying to create a just society. That's not where he comes from. He did not examine whether the truck driver was treated fairly. He examined the rules of the company, their policies, and any applicable laws. And he said, I'm sorry, I can't give you the relief you're seeking. This is not my job to create the just environment for you. An Earl Warren and the people from that era would have looked at that differently, but these literalists, they take everything. Justice Scalia would never save a statute because it was poorly worded. He would say, I'm sorry, I'm not the writer of this. I can look at this and I can think of a way that would make it constitutional to save it, but I can't. That's not my job to save the statute. So therefore, it's invalidated. If the wording could not get to the desired result with Scalia, you would get no mercy for him. The statute fails because it's not correctly worded. If he's coming from that perspective, then there will be opportunities for us to benefit from things that go before the Supreme Court if he holds to that. Because like with Scalia, we always could count on his vote on confrontation. He was always going to say, the damn Constitution says they have the right to confront their accuser, and that means confront them. That doesn't mean by video. That doesn't mean by a proxy. That means direct confrontation. And so this may be a good omen for certain issues for us that we want to go to the Supreme Court.
And he didn't vote with the liberals for the same reason. If I'm not mistaken, the liberals voted for this because something like deporting somebody could be considered cruel and unusual punishment, and they sided with Dimaya for that reason. But Gorsuch sided with the liberals, but he had his own agenda. He had his own reasoning.
He did. He wrote a separate concurrence, which got him to the 5, but he didn't agree with the same. He's not in the do-good business. So he was writing strictly from a constitutional perspective, as far as I could tell, that there was not sufficient clarity here in terms of the it has to be written with sufficient clarity to provide notice, and they didn't do that. So therefore, it falls.
And what would be the difference between violent and nonviolent crimes beyond the obvious of, I don't know, punching somebody in the face versus writing bad checks?
Well, let's just take a look at what does violent mean according to Webster.
Okay.
So because in my mind it's pretty simple. That there would have to be some application of force for it to be violent. But the victims' advocates have convinced us a lot of things is not convinced me, but they've convicted lawmakers that a lot of things are violence, that where there's no violence at all. So let's find out what Webster says violence is.
Yeah, we probably need to hit what is it, Black's Law Book or whatever. What's the name of the law book?
Black's Law Dictionary. But I was going to look at a common. The average person doesn't run around with Black's Law Dictionary, but the average person does have a Webster.
Well, violent felony, a crime consisting of conduct that presents a serious risk of potential injury to another that is punishable by imprisonment for more than 1 year, used especially in federal sentencing of career criminals guilty of crimes involving use of a weapon. That's vague too, because a weapon could be your pinky, a pencil, slime. I don't know. That leaves that open to a whole bunch of interpretation too.
Well, let's just look at Webster. The use of physical force so as to injure, abuse, damage, destroy. Well, would breaking in a house be use of physical force so as to injure, abuse, damage, or destroy?
You did not break into the house with the intent of being violent to the occupants, only to the house.
So another definition: intense, turbulent, or furious, or often destructive action or force. The violence of the storm.
Okay.
Injury by or by distortion, infringement, or what the heck?
So someone that happens to download some nudie images and they happen to be underage, that wouldn't qualify as the definition of violent.
Not in the average person could not come to that conclusion, and that's what if we're interpreting the Constitution literally, that's what's required. We have to give an ordinary person sufficient notice. So if we're going to take your residence away from you, we're going to deport you. We need to tell you what a violent crime is that'll get you deported. Here's another one: the use of physical force to harm someone, to damage property, etc. Great destructive force or energy.
I'm trying to tiptoe around the idea of where does contact level sexual offenses become violent crimes?
I don't know. I would apply the same standard.
And it feels to you would know this better than me, but it feels that the majority of sexual offenses, regardless of their nature, are considered violent crimes.
Unfortunately, that's what we're talking about. That's why I think this decision is helpful. The lawmakers have largely at the behest of prosecutors and victims advocates have said these are crimes of violence. You hear debates, and the people on the advocate side say that every sexual offense is a crime of violence. No, it actually isn't.
Well, let's think about the one, what was it, in Connecticut or Vermont, where the teacher and the 18-year-old boy, that was completely consensual, but she could end up on the register. If everything goes against her, she could end up being convicted and be listed as under a violent crime for consensual sex with an adult.
So I'm not sure that that'll get her on the violent list, but certainly if he were a minor, that would have a greater chance of getting it. But that doesn't. It can also be consensual. But the victims advocates will tell you that since a person's a minor, they can never give consent. So therefore, it's still violent.
But they'll perfectly bring somebody into court and try them as an adult for some sort of heinous crime.
Well, that's one of the inconsistencies of the many. But yes, a crime of violence should be narrowly. Anything that's going to be considered violence should have some act of aggression in it, rather than passive. To me, that would be a requirement for something to be violent.
Do you think that Dimaya's immigration status matters, whether he's a legal or an illegal immigrant in this case?
Well, absolutely, it mattered because he was legal. He had a vested interest. He had a property interest in his residency in the United States, and so taking that away from him with all this ambiguity would be different than someone who had just broken in the middle of the night and was here committing crimes. His immigration status had everything to do with the fact he was lawfully here. And unfortunately, we have conservative talk show hosts out there, Michael Levin, for one, who distorted on his radio show, which reaches millions of people, claiming that he was illegally here, and this is catered to the illegal aliens. This has not anything to do with illegal aliens. This is to do with legal residents.
I went back and I listened to it, and he did say and he's not even supposed to be here.
So, and that's unfortunate because that's pumping hatred and playing into the divisiveness that goes into this country about. I mean, we've all of a sudden become very disgusted that the people that we depend on to do our work that we don't want to do are here, and so these people who come in, certainly those like Dimaya that came in legally, shouldn't be breaking the rules and burglarizing houses. We'll all agree on that. But if we're going to kick him out, we need to make sure that he understands, and all people in his situation understand, that if you break the rules and commit this type of offense, you will forego your right that you've earned to be in the United States, and you will be sent back to whatever your country of citizenship is.
The second clause of that, what is it called? The void-for-vagueness doctrine. There's a second clause in there, and I'm hoping you can shed some light, because I understand all the words, but when you put them together, it just becomes legal mush to me. And it says that if a legislator's delegation of authority to judges and or administrators is so extensive that it would lead to arbitrary prosecutions. And you already touched on it a little bit, but can you open that up a little bit?
Well, that's kind of what appears to have happened in this case. The immigration judge determined it was a crime of violence arbitrarily because he or she, I don't know which gender, but the immigration judge didn't have sufficient succinct clarity into what to classify as a crime of violence. So looking at, well, that's a crime of violence. Somebody busted in somebody's house.
Right.
Well, but with that precision in drafting, which we're capable of doing, there's a lot of linguists in this country. We can define a crime of violence sufficiently so that an immigration judge can say, nope, that's not violent. Yes, that is violent. And so that led to arbitrary. The speeding example I gave, that allowed that immigration judge to define a crime as violent because of lack of specificity and clarity to guide law enforcement to prevent that from happening. And your registries have a lot of that. And when you're trying to figure out what you need to do to comply,
right?
Lots of times you call the registry office, they don't know.
Right. And we talked around when did it become violent for him to break into these houses? Like, once he crossed the property line? Is it when he broke the window? Is it when he pushed through the door? When did it become violent?
Or maybe he opened the unlocked door.
Right. So yeah, that leads back to the vagueness.
So what they're going to have to do, and they're going to have to go back and define for immigration purposes under the Immigration and Nationality Act a crime of violence with sufficient precision that anybody who's here as an immigrant knows that if I engage in this type of criminality, that not only will I be prosecuted, that I will be subject to deportation at the end of my sentence. So that's all they have to do. The Supreme Court didn't say that you can't deport these people. They say you have to give them notice of what constitutes a crime of violence under the Immigration and Nationality Act before you you got to draw that sufficiently clear so that it can't be arbitrarily and capriciously enforced. And for some reason, that bothered Mr. Michael Levin.
Right. And we danced around, we at least just touched on it, about if you are here from France, wherever, you are here legally, but you're just on, say, a tourist visa, and you commit a crime, you have the constitutionally protected protections that, God, I'm speaking in circles. You have the same rights as a person in the state as far as the judicial process going towards you. Miranda rights, right?
Yeah, correct. You have the right to remain silent.
So I'm going to make the assumption that a tourist visa has a less status than somebody that's here legally, like with a green card, that is a permanent resident of the United States.
That is correct. When that tourist is finished serving their time, they would be deported without the same benefits of the Immigration and Nationality Act because they haven't gone through the Immigration and Nationality Act to be here. So at the end of their conclusion, they would be summarily deported unless they applied for a waiver. And I'm not an immigration expert, but unless they qualified for some sort of asylum status or something, they would be deported almost immediately at the conclusion of their hospitable stay in the prison if they got sentenced to prison. If they were sentenced to probation, they would probably be deported as soon as they're put on probation. They would probably be deported to leave the country, because if they're breaking the law to the point they need to be put on probation, we wouldn't want to take the chance they would continue to break the law, so they'd be put on probation and then deported.
Have we beaten that dead horse?
I think we've had a lot of fun with that horse, and I'm optimistic that we're going to get some. It'll be a slow process. People have to understand that a Supreme Court decision doesn't magically mean that things change overnight. All they need to do is look at Packingham, North Carolina. There's a lot of people still being prohibited from using social networking, even though the U.S. Supreme Court said the North Carolina statute was overly broad and it intruded in an area, particularly for those who had served their time. The other 49 state legislatures are not going to magically convene and say, let's address this. Somebody has to challenge, and they have to cite to this case, and it has to work its way through the appeals process in those states so somebody who's in a registrant, for example, in one of the states who's labeled violent. Virginia has everybody labeled violent. So maybe someone in Virginia will come and say, I'm not a violent offender, and they will cite to Sessions versus Dimaya and say, you can't do that because I wasn't given proper notice before you classified me as a violent offender. I could not have comported my conduct to the requirements of law because you had not defined this in advance. I mean, there will be challenges that will work their way through this. I'm hoping that we will see a slow progression from everybody being labeled violent offender that's not violent. And like in Georgia, I think you guys have a whole lot of things that are called violent simply because that's what they wanted to do. This is a violent offense when it really isn't.
Yeah. Pretty much if you end up in front of a judge, it's going to be a violent crime here.
What kind of place are you? Oh, I forgot. Georgia started out as a prison colony. That's the original history of Georgia.
That is correct.
When they were cleaning out all their prisons, they dumped them on what was this, James Edward Oglethorpe.
You know more about the history here than I do. That's for sure.
So, where the hell did you come from?
I'm originally from Maryland.
Uh-huh. Well, what was the order of admission of Maryland in the states of admission? Do you know off the top of your head?
Heck no, man. I didn't study in school.
Oh, yeah. I think Georgia was fourth. So,
I have no idea.
So we were in the late. We weren't in my state. We weren't admitted till a long time later, 1912. Wow. So
as a side story, one of my first interactions with people while I was gone was that they said that there were 52 states. I think I've shared this story with you, but these 2 or 3 guys, they were talking. It's like, yeah, man, that's why there are 52 states. I was like, wait a minute. No, there are not. And things almost got violent over me saying that there are 50 states versus 52. And they wanted to say that Cuba was a state.
Well, I don't see any problem with that. 52 states.
No. And Alaska and Hawaii were the last 2, but I still couldn't figure out how they got to 52. But
Georgia was 4th, Maryland was 7th.
All right. But those all happened, the 13 colonies, they all happened like
very close together.
Yeah. Well, I mean,
Georgia was 1788 and Maryland was 3 months later, April 28th.
I was going to ask if they were like within days or months, or was it spread by years?
So the first admission was Delaware, December 7th of 87, and then of the 13, the last one was Rhode Island, May 29th of 1990.
1990.
So, I mean 1790. That was a little bit of a slip. So.
Ready to be a part of Registry Matters? Get links at registrymatters.co. If you need to be all discreet about it, contact us at registrymatterscast@gmail.com. Call or text a ransom message to 747-227-4477. To support Registry Matters on a monthly basis, head to patreon.com/Registry Matters. Not ready to become a patron? Give a 5-star review at iTunes or Stitcher. Or tell your buddies at your treatment class about us. We want to send out our big, heartfelt support for those on the registry. And don't forget to say, fuck you people. You fucking matter. You make it possible. All right.
And,
so moving on. We have one final article, and it'll be just kind of quick, and it's from Vox.com, and it comes from the camp of don't talk to the police unless you have to. And it's quoted in the article that says the ability to prosecute and jail people for lying to investigators is obviously an incredibly powerful tool of the FBI, U.S. Attorney's Office, and other aspects of federal law enforcement. It's also prone to abuse in some fairly obvious ways, especially because it's perfectly legal for investigators to lie to you. That's why standard legal advice is simply to refuse to talk to investigators under any circumstances. People seem to think that if you haven't done anything wrong, then it's okay for me to talk to the government, writes defense lawyer David Benowitz, and that's just dead wrong. Now, this comes from an article from Vox where they were talking to James Comey and at the release of his recent book. And we've talked about this subject before about keep your damn mouth shut. Nothing good will come of it. And that goes to like the lady in Virginia that we spoke about last week.
We did speak to her, and she confirmed my suspicion that she was very helpful to the police.
Oh, did you? You talked to her offline?
No, I mean, we talked to her
okay.
on the call. Yeah. So, but this is standard advice that everyone should heed, is that when law enforcement comes to talk to you, rule number one is if they had an open and shut case, they would not need to talk to you. They would simply arrest you because they've already got their case open and shut, and they can convince a jury unanimously that you're guilty. So they don't need your admission. They talk to you because they need your admission to convict you. So, and since it's unlawful, Martha Stewart learned the lesson quite well. More recently, former House Speaker Dennis Hastert learned the lesson when he talked to the investigators about his staggered withdrawals that he was doing from his bank account to pay hush money to one of his victims of his sexual abusiveness when he was a wrestling coach in Illinois back in, that was an unfortunate tragedy. But he talked to the police, he talked to the investigators, and told them he was fearful of bank safety, so therefore he was taking his cash out. So you should never talk to law enforcement unless you're being counseled to do so by a legal professional. And that doesn't mean a person that the cops has brought to you and said this person's an attorney. That means someone that you have a relationship with. And it's not likely to have a good result when you talk to the cops. But people do it all the time. And the cops are trained in interrogating the good guy, the bad guy. They use all these tactics. They understand you. We're guys. I mean, tell us about how much porn you downloaded. Tell us about having sex with that 14-year-old. Hell, I was when I was a younger man. When I was in my 20s, I could understand somebody having sex with a 14-year-old. Hell, I found them hot myself. And they get people to open up, and then they use your words to convict you. So there's nothing good going to come out of it. And then you're going to run the risk of getting prosecuted for misstating something, particularly for federal, if you mislead a federal investigator. And so you may omit a fact, or you may have a fact wrong, and then they're going to prosecute you for that. So I just tell people, unless an attorney is giving you advice to talk and it's in a supervised environment, politely decline their invitations. And if they say we're going to have to arrest you, say, well, I understand you've got to do your job.
But this is significantly after the barn door is closed. I mean, typically people think that it's like, well, I haven't done anything wrong, I should just go talk to them and cooperate. But until somebody ends up in one of these situations and can learn it from firsthand experience, it's not like we're teaching this in school. We're not teaching them how to balance a checkbook, and we're also not teaching them to keep your mouth shut.
Well, it goes against what you've been taught growing up. You don't grow up, unless you grow up in a minority community in a high crime area where you see a lot of police misconduct on a more regular basis. You grow up thinking that the cops are your friends, and they come to the school with their nice uniforms, and they help you cross the street, and they're your friend. So when a cop comes out to have a conversation with someone who's never had any experience, they don't have any basis to not trust the cop, none whatsoever. Right. So it's counterintuitive to everything that they've of all their values. They believe that the police department's overworked, underpaid, short-staffed. They would never do anything like that to them, because even if they did something even slightly bad, the cops have got too much to do to concentrate on bullshit. So it's just counterintuitive. So you're right. When a person has an encounter, they believe that being rational, being truthful, will take care of it. It's the same. Do you remember John Benet Ramsey in Boulder?
I do know the name. Cute little
The
blonde-haired girl.
little girl. Well, those were very affluent pillars of the community. The Ramseys were, and they would have had those same values when the cops came to their house. And the cops, to the credit of the police, they were more generous with how they treated the crime scene than they would have been to just any ordinary family. They afforded the Ramseys a lot of courtesy to be in their home while they were conducting an investigation. But when the investigation clearly turned on the Ramseys, and the cops made it clear that you are a suspect until you prove that you're not, they became quite indignant because it went against everything that they could believe. Our little girl's been killed, and there's a killer out there, and they're focusing all their energy on us. We need to lawyer up here because they've made it clear that we are the focus of their investigation. Well, most people, that goes counterintuitive. They say, well, I would do anything to find my little girl. Yes, you would, until they make it clear they're trying to prosecute you.
Right.
And then when they say, well, we've got this handwritten note and it's for $112,000 worth of ransom, which is exactly what your husband or thereabouts, close to what he got in a bonus. So therefore, this tells us all we need to know. Of course, there could be other people who knew that he got a $112,000 Christmas bonus. But once they make it clear that you are the target and we're coming for you, then they lawyered up. You'd be crazy not to lawyer up under those circumstances. But you have to be in those circumstances before you would know how to react. But intuitively, you would say, "Of course I would. I would take a polygraph. I would do anything to get." Well, of course you would. Who wouldn't? Until they tell you they're getting ready to lock you up.
Whoa! Now you've gone too far. Hang on. We need to back this up. Yeah, I don't see. I'm trying to figure out how to convey this message to my son about. Just treat them with a large degree of skepticism about their intentions. Where, I mean, if you've got somebody breaking into your house and you dial 911, you want the police to be there as lickety split as possible, and that's their job, and that's what you're expecting them to do. But at the same time, if they're going to come talk to you about perhaps some sort of criminal action, you just and then you have to incur, you haven't done anything, you just happen to maybe witness something. And you don't want to talk to them without a lawyer. So now you've got to incur the cost just for existing in society.
That is unfortunately the reality. When they come to talk to you, they can tell you you're not a suspect and they can be lying to you because it's okay for the cops to lie.
That's, God.
They can tell you, well, you're not a suspect, sir. We just need some information. We're trying to close this case and we're trying to get the bad guy. And you may be the person they're trying to get.
Right.
You don't know that. And it's very counterintuitive because you want to help solve the crime.
Because you want your community to be safe. Yes.
So you're going to want to talk to them. Only you know if you're involved in it for sure.
True.
Well, sometimes that is not enough, not being involved in it. Sometimes there's enough circumstantial evidence that could put you in a bad light. And I use the example of DNA. DNA can be in, hypothetically, you pick up a hitchhiker. In most instances, they're going to leave DNA in your car, right? It's a little bit as I understand about DNA, but it's hard to sit in the car for 2 hours and not leave some DNA. A hair is going to fall out.
Mm-hmm. Some skin's going to flake off.
You're going to put a cigarette butt in the ashtray or any number of things going to leave some DNA.
Or fingerprints, but I'm with you on that. Yep. Mm-hmm.
So, and then the person ends up dead down the road somewhere after you've put them out safely. Well, the cops come to you and say, well, how did we can place him in your car? The DNA's there. You sure the DNA's there? Doesn't mean I killed him.
Right.
But it's circumstantial. Well, you need to tell us. Well, I tell you, I was driving across the country and I saw this hot thing on the road and gave him a ride. And okay, well, what else happened? Well, you don't want to tell them that you actually had a fling in the hotel room because you let them stay overnight with you, and because you're married, and you don't think that's going to look good to your spouse's opinion of you, so you start lying. Well, actually, what we did is I went to a hotel room. I went to my hotel, but I didn't spend the night with them. We had a drink, and then I let them go on their way. Well, then you've just told another lie. And pretty soon the cops start finding out that you're lying, but you still didn't kill the person.
Right.
And then they start confronting you with your lies. And they said, now this is going to look awfully bad because you told us a lie you didn't have to tell us. Well, you did have to tell them that because your wife isn't going to appreciate, or your husband, whichever gender the case may be, that you went and picked up a hitchhiker and had a fling when you're on a business trip when you're supposed to be working. So things can look bad, and that doesn't mean the DNA can tie you to the person, and you can look bad and you didn't kill them.
And they have
But you did.
effectively unlimited resources to just fuck with you until you cave.
Well, if they can't find any other rational explanation for the person's disappearance, you're the last person that they can place. I mean, we've got you the hotel. We can see you that you checked in. We see they were there with you. You admitted you had a romantic fling with them, and now they're dead. Sure does look bad, doesn't it?
That does sound like it looks pretty bad. I don't like your example.
I mean, but I'll tell you what, we'll offer you a plea to second degree. Of course, we don't have the body yet because you haven't told us where it is. So they're going to try to get you to tell them where the body is. Of course, if you didn't kill the person, you're not going to be able to tell them where the body is because you don't know.
But they're going to keep their thumb on you until you cop to something.
If they can't find anybody else, you better hope that somebody else, another suspect, surfaces.
Yeah.
So you can get yourself in a really bad situation and not have done anything wrong. And the average person doesn't understand that.
Sure.
They just can't. They can't relate to, if you haven't done anything wrong, the mantra is, I've got nothing to hide. I don't care.
Right.
Well,
right.
Actually, it doesn't work quite like that.
Doesn't seem to.
The Ramseys had nothing to hide. They killed no one, and their lives were destroyed. They left Boulder and went to Atlanta, and then the wife died, as I recall, before they were ever cleared.
Wow.
But I think he lived long enough for them to say that actually that this is not, we made a mistake, that they were not involved in this at all.
The consequences are so extreme. They are so lopsided in the other direction for the prosecution side, for them to put their thumb on you so hard. Yeah, they know it deep inside. They know they did it, but it turns out that they didn't know it. But the consequences for our side of it, for the defendant's side, is so extreme.
Very few people can match the resources of the government, be it state or federal.
Yeah.
So if for whatever reason, if you get in this system, it's tough for you, as you're fighting with a lot of your hands are clearly behind your back compared to the resources they have, and it's not a fair fight. And it's tragic because we grow up thinking that it is a fair fight. We're grilled that you're innocent until proven guilty. You'll have a competent attorney. All this due process stuff. But in reality, like we talked about earlier in this podcast, with the system rigged, especially if you've had any type of trouble before, I mean,
right.
that just compounds your problem. If you've ever been in any type of legal trouble before,
you are doomed.
So.
Well, thank you very much. Again, this is episode 21, Larry. I think we're doing great, and I appreciate your time as always.
So how can people support the podcast, Andy?
Oh, well, they can support it. Now, specifically, go out and share it. Share it over Twitter, Facebook. I don't care. However you want to pass it along to your buddies. And we have a Patreon page. You can find us on YouTube. You can find us at iTunes. You can subscribe all over the place. Anywhere, any podcast app that you're using, you can find it. And if you feel generous, support us on Patreon so that we can buy Larry some better equipment.
So how well did we do on packet loss today?
We did awesome. No packets lost.
So maybe I think we found the solution.
I do too. Makes my life a lot easier trying to correct everything.
So, well, thanks a lot, Andy.
Have a great night. Bye.
Bye.